Driver suspension, DHSMV hearings. If you or a loved one has been arrested for a DUI, it's not just the criminal case that you'll have to contend with, but also the Department of Highway Safety and Motor Vehicles administrative suspension of your license. It's almost as though there are two separate cases going on related to your license at the same time. You have an administrative suspension and then later a criminal suspension. The first and most pressing thing you have to deal with after getting arrested for a DUI is making sure that you act within the first 10 days to preserve your driving rights. When you're arrested, the police will confiscate your driver license on the spot. Once you're processed and released from jail, you'll be able to use the actual citation that you received for the DUI as a type of 10-day temporary license to drive. It actually says it on the bottom of the DUI citation. Your actual license will be suspended by the Department of Highway Safety and Motor Vehicles in response to your arrest and alleged violating of driving laws. What you may not realize is that during the 10 days where you're issued a temporary license in the form of this citation, you can request a hearing at the Department of Highway Safety and Motor Vehicles in order to appeal this automatic suspension, or you can request a business purpose only license. If you do not request a hearing or you don't apply for your business purpose only license, your driving privileges will be completely suspended for 6 to 12 months or longer if you had a prior DUI. It's imperative that you act within 10 days of your DUI. Although it's just a technicality, your license is not actually suspended because of the DUI arrest. Instead, your license is suspended because you either registered a blood alcohol content level in excess of 0.08 or you refused to submit to a breath test in the first place. Refusal to submit to a breath test results in an automatic suspension because of the implied consent laws that comes along with receiving your Florida driver license. You can actually see this implied consent written on your license. This implied consent states that by accepting the driver's license, you're willingly agreeing to submit yourself to a breath test when requested by a law enforcement officer. This is one reason why the DMV hearing is completely separate from your criminal trial. The DMV operates as an independent body that issues driving privileges in the state, and they reserve their own right to issue or revoke those privileges. After your arrest, you have two options, and you must pick and exercise that option within 10 days of your arrest. Option 1 is to request a formal review hearing and challenge the driver license suspension head-on. Option 2 is to request a business purpose only license, also known as a hardship license, which will allow you to travel to work, to church, or to the grocery store for other means of living. If you choose to have the hearing, know that this is not a criminal hearing, it's an administrative hearing. So the burden of proof is much lower, meaning that it's much harder to win an administrative hearing for your license than it is to actually beat the entire DUI case. At the hearing, the arresting officer will need to be present and will need to submit the evidence that they gathered when they took the breath or blood or urine sample in order to determine your blood alcohol content. At the same time, your attorney will seek to prove that the officer did not have probable cause for the traffic stop or that they did not have probable cause for the arrest of the DUI, which in turn invalidates their decision to issue a blood alcohol test in the first place. There are a variety of other details that your DUI attorney will go through with you in order to identify what, if any, holes there are in the officer's case. And your defense attorney will use this as an opportunity to question the officer under oath without a prosecutor present. If you're successful in your hearing, you'll be allowed to retain your driving privileges. If you lose, you'll lose the right to drive completely for at least 30 days, and then you can apply for a business purpose only license. So if you can afford not to drive for 30 days, there may be some value in you having one of those hearings. If not, then it may be in your best interest to apply for a business purpose only license and let your attorney focus their attention to your criminal case. If you do not request a hearing or apply for a business purpose only license within 10 days of your arrest, then your license will automatically be suspended by the DMV for the set amount of time that corresponds with your history of DUI charges and convictions. If you or a loved one has been accused of a DUI in Central Florida, call my office immediately so that we can act fast to help preserve your driving privileges. Remember, you have 10 days to preserve your driving privileges, so you must act quickly. The quicker you take action, the better your outcome will most likely be. Thank you for watching the video. I hope you found the information to be helpful. As always, nothing I said in this video or in any of my videos creates an attorney-client relationship between myself and whoever's on the other side of this video camera.